Right. So, good evening to all of you. Again, I'm very happy to have our third webinar series, right? Third one in the webinar series. Now, today we have decided to speak about from Nuremberg to the Rome Statute, ending an era of impunity. And today I'm very happy to say that we have with us Professor William Shabers, who is an expert in this field, along with Professor Vasanta Seniviratne, Head of Department of Public and International Law. And unfortunately, Dr. Sampath Kiheva, who was supposed to be here, Dean, Faculty of Law, is not able to join right at the moment, but he said that he's also going to join. So actually now we had a first webinar on August with Professor Adimola Abbas. Then we had another one with Professor Clabbers. And now today we are going to have one with Professor William Shabers on basically a topic on international criminal law. And when we talk about international criminal law, we know that it is always a controversial issue. There is no point in denying that. But the fact is that many of the people, even some of the academics and even the practitioners, may have some misunderstandings and misconceptions about what, how this international criminal law really applies, and especially when it comes to prosecutions that are conducted, how they are going to be done. And without, going further, I would like to invite so Asanta Seniviratne to give a brief introduction about Professor William Shabers and to open the forum. Over to you, madam.
Thank you, Mr. Akalanka. Aibowan and good evening from Sri Lanka. I am really honored and privileged to introduce Professor William Shabers, one of the great scholars and very well known professor in human rights as well as international criminal law. So Professor very kindly agreed to accept our invitation to deliver the webinar titled From Nuremberg to Rome Statute to an era of ending impunity. I understand it is not easy to introduce such a great scholar in a few minutes' time. I believe this brief introduction only iota of what he has done. So a very humble reflection of thousands of great scholarship that he has contributed in the field of human rights law and international criminal law. Professor William A. Shabers is a professor of international law at Middlesex University in London. He is also a professor of international human rights law at Leiden University, emeritus professor of human rights law at the National University of Ireland, Galway, and honorary chairman of the Irish Centre for Human Rights, and an invited visiting scholar at the Paris School of International Affairs. Professor Shabers is a dual tenant at the chambers of 9 Bedford Row in London. Professor Shabers holds BA and MA degrees in history from the University of Toronto and LLB, LLM and LLD degrees from the University of Montreal, as well as honorary doctorates in law from several universities. He is the author of more than 20 books dealing in whole or in part with international human rights law, including Introduction to the International Criminal Court, Cambridge University publication in 2020, and Novak's commentary on the International Covenant on Civil and Political Rights in 2019, the trial of the case, which is an Oxford University publication in 2018, the International Criminal Court, a commentary on the Rome Statute, again an Oxford University publication in 2016, the European Convention on Human Rights, a commentary, Oxford University publication in 2015, the Universal Declaration of Human Rights, Trao Preparatua, Cambridge University publication in 2013, Unimaginable Atrocities, Justice, Politics and Rights at the War Crimes Tribunals, again an Oxford University publication in 2012, Genocide in International Law, Cambridge University publication in 2009, and the abolition of the death penalty in international law, again a Cambridge University publication in 2003. So just to name a few. In addition, Professor Shebas has published more than 400 articles in academic journals, mainly in the field of international human rights law and international criminal law. Professor's writings have been translated into several languages, including Russian, German, Spanish, Portuguese, Chinese, Japanese, Arabic, Persian, Turkish, Nepali, and Albanian. He has lectured in more than 50 countries from 2002 to 2004. He served as one of the 3 international members of the Sierra Leone Truth and Reconciliation Commission. In 2014, he was appointed as chairman of the UN Commission of Inquiry into the Gaza War. Professor Shebas has worked as a consultant on capital punishment for the United Nations Office of Drugs and Crime, and drafted the 2010, 2015, and 2020 reports of the Secretary General of the status of the death penalty. Professor Shebas was named an Officer of the Order of Canada in 2006. He was an elected member of the Royal Irish Academy in 2007. He has been awarded the Vespasian V. Pella Medal for International Criminal Justice of the Association Internationale di Droit Penal and the Gold Medal in the Social Sciences of the Royal Irish Academy. So this very brief and humble introduction would allow our audience to understand the significance and the contribution made by Professor William Shebas in the respective fields of international human rights law and international criminal law. So in Sri Lanka, which is ravaged by an armed conflict, which was witnessing a protracted armed conflict for about 3 decades, which was ended in 2009. And we are aware about many of the accountability issues that has been spoken at various forums. However, we are not moving to those politics or the practicalities, but we thought in Sri Lanka, the audience in Sri Lanka, as well as some of the foreigners that who have joined with us today, would be very much interested to know about how this international criminal law justice and justice to the victims and to end an era of impunity has been progressively developed aftermath of the Second World War, after the very infamous Holocaust, as well as the Nuremberg trials and the judgments of the Nuremberg Tribunal, then afterward from Tokyo, then to the most well-heard ad hoc international criminal tribunals, namely International Criminal Tribunal for former Yugoslavia, International Criminal Tribunal for former Rwanda, for Rwanda. And after all of that, for the first time in the world, a permanent international criminal court with the adoption of 1998 from Statute of International Criminal Court. So in our country, in the law school, Sri Lanka, in the Faculty of Law and elsewhere, we have been teaching international law, public international law, international human rights law, international humanitarian law, and international criminal law. Some occasions only in the master's level, and certain occasions both in the undergraduate and master's level. So our audience, I'm sure, would be very keen to listen to Professor William Shebas. Sir, thank you for accepting our very kind invitation despite your busy schedule. So it is over to you, Professor, to start your deliberation. Thank you.
Thank you very much for the very nice introduction. And it's my pleasure to join you. I wish I could be there in person, and I hope that at some point in the future, I'll be able to make a trip to Sri Lanka and see what I know to be a very beautiful country. The title of my presentation today suggests 2 institutions, the Nuremberg Tribunal and the International Criminal Court, as kind of bookends of a process of creation of international justice. The focus on the institutions is one way of dealing with the subject, of approaching the subject. But it is important to bear in mind that international criminal law also refers to the substantive law, the definitions of crimes, the forms of participation, which are to be applied in domestic law. So in some ways, it's important to divide the subject into two. There are two dimensions to it. One is the existence of international institutions charged with applying the substantive law of international criminal law, international criminal justice. But even if we do not have those institutions, or even if they're not operational, there is still a huge body of law relating to the prosecution of international crimes before domestic courts. And today, at the present time, we have a situation where the International Criminal Court has 123 members, 123 states parties to the Rome Statute. But that means there are more than 60 states that have yet to ratify or accede to the Rome Statute. They are not members of the International Criminal Court. There are ways in which the International Criminal Court can reach their territory, but these are more the exception than the rule. And we have to say as well that among these 60-odd countries that have not joined the International Criminal Court, we include, I think, the 6 largest countries in the world. So it's an incomplete system. It has a great deal of momentum, but it is not by any means covering the entire globe. And yet the subject of international criminal law is also of great relevance to those countries that have not joined the Rome Statute, that have not ratified or acceded to the Rome Statute. And so I'm going to, in the course of this webinar, take up both of those dimensions to some extent. The other point I'd make about the title is to say that while Nuremberg is in many ways the great defining moment of the beginning of the process, because Nuremberg refers to the great trial that took place in 1945 and 46 after the Second World War. It was the first international tribunal to be created. It was created by the 4 great occupying powers of Germany. In parallel, to some extent, with the Nuremberg Tribunal was, of course, the Tokyo Tribunal, more well-known and more appreciated in Asia. And the Tokyo Tribunal, which was in many respects quite similar to the Nuremberg trial. So they were both part of a very, very important process, period, in the development of international criminal law. We can actually go back even further. We know that if we go back to the beginning of the 19th century, and here the important date is 1815, when Napoleon was defeated at the Battle of Waterloo, and he was then taken prisoner by the British and he was kept on board a ship while they decided what to do with him. And there was then no sense that there was any form of international law that might be relevant. The British wondered what to do with them. They didn't want to hand them over to the Germans because the Germans had said they would kill them immediately. And the British didn't think that was the decent thing to do. They considered putting him on trial, but they said there was no crime, there was no framework within British law to try him. They suggested giving him back to the French, but the French didn't want him back. And so finally, they enacted special legislation to facilitate his detention without trial on St. Helena, where he spent the next 5 or 6 years before dying, apparently of natural causes. And St. Helena provides a kind of a precedent, a model for a modern day island in the Atlantic or in the Caribbean, which is the Guantanamo base in Cuba, where people have been detained without trial now for more than a decade, for many, many years. But this is the exception rather than the rule, fortunately. There was talk of having an international trial by Bismarck, the Chancellor of Germany, after the Germany defeated the French in the Franco-Prussian War of 1870. And of course, Napoleon had died 50 years earlier, but it was his great nephew who was then the French emperor. And Bismarck flirted with the idea of actually holding an international trial, only to abandon the idea. Where we have the first genuine effort at international criminal justice was in 1919, when at the Paris Peace Conference, a commission was set up. This commission, called the Commission on Responsibility, was composed of the 15 of the most eminent international lawyers in the world. They spent the better part of 2 months trying to create, basically from whole cloth, to create an international criminal framework, both the substantive law, the crimes, and the institutions. And this led to a provision in the Treaty of Versailles, Article 227, which called for a trial of the German emperor, who by then had been deposed, he had abdicated, and he had been given asylum in the Netherlands. The trial never took place because the Dutch government refused to surrender him, refused to extradite him for trial for complex reasons, which I won't go into today, but you can read about it in my book, The Trial of the Kaiser, where this is all explained. And then then very little happens in international criminal justice for a period of about 20 years until the Second World War, when the discussions become, when there's more momentum for the idea, and we have the first International Criminal Tribunal. So that period after the Second World War is very rich, because it represents not only the first experiment with an international tribunal, the two international military tribunals, one for Europe and the other for the Far East, but it also represents a period of creation of the substantive law to apply to international criminal law. And in particular, the development of the notions of international war crimes, of crimes against peace, or the crime of aggression, as we call it today, and two related concepts, crimes against humanity and genocide. The crime of genocide was not prosecuted in principle by the Nuremberg Tribunal. What we now today know as genocide was prosecuted, but under the label of crimes against humanity. And at the Tokyo Tribunal, there was really very little in the way of prosecution of crimes against humanity, because unlike the Germans, the Japanese didn't persecute their own civilian population. The notion of crimes against humanity had been created at Nuremberg so that international justice could deal not only with the war crimes committed by Germany and the conduct of an aggressive war, of a war of aggression, but also so that the atrocities committed by Germany during the Second World War against its own civilian population, primarily the Jewish population, could be addressed, and it was. But there was a catch. At Nuremberg, the four great powers who set up the tribunal, the United Kingdom, France, the United States, and the Soviet Union, decided to limit the notion of crime against humanity to atrocities that were committed in connection with the aggressive war. And this was a very, very damaging limitation. It was done, we know, for very transparent reasons, but very cynical reasons, because all four of those powers who set it up were haunted by the fact that if they were to recognize a category of crimes against humanity, of atrocities that a government could perpetrate against its own population in time of peace, that they might be vulnerable to charges that they had committed crimes against humanity as well, both against their own civilian population in their countries. I'm thinking, for example, of the United States, where you had a terrible system of racial discrimination at the time that people called Jim Crow, and also the phenomena of lynching. And in the case of Britain and France, of course, you had their extensive colonial empires at the time, where they considered themselves to be exposed to the possibility of prosecution. And so this was the reason why they limited the category of crimes against humanity. And it provoked a response within the United Nations General Assembly in 1946 that was promoted by a man named Raphael Lemkin, the man who had developed the notion of genocide, but that was pushed forward in the United Nations General Assembly, in particular by India. And India, at that first session of the United Nations General Assembly, played a huge and significant dynamic role in pushing the General Assembly of the United Nations, not only to address the crime of genocide, but to address racial discrimination more broadly. And India was directly involved in proposing the resolution on genocide and directly involved in proposing a resolution on the treatment of the Indian minority in South Africa and other activities. And that continued for many years. There was work that followed on international criminal justice after the trials at Nuremberg and Tokyo, notably the adoption of the Genocide Convention by the United Nations General Assembly in 1948, the creation of a special category of war crimes known as grave breaches, and that was created outside the United Nations system when the 4 Geneva Conventions of 1949 were adopted. And then work that went on within the United Nations, principally within the International Law Commission, but also within the General Assembly, to prepare the basic, to do the groundwork for a permanent international criminal court. In 1954, the General Assembly put a halt to it. There was little appetite within the United Nations. At that time, it was the time of the Cold War, and there was great anxiety about the whole notion of international criminal justice. And so it was put on hold, kind of in suspended animation. Most of the historians of the development of international criminal law talk about a period where there was really no activity between the early 1950s and the end of the 1980s. But I don't think that's accurate. And I want to insist on important developments that took place in the 1960s and 1970s. And they were driven by countries of the global South, notably the countries, the new countries from Africa that were created as a result of decolonization. And when they started to basically throw their weight around in the United Nations General Assembly, they soon turned to international criminal law as a means to address the phenomenon of apartheid in South Africa and racial discrimination and apartheid-like measures in other parts of South Africa, such as Southern Rhodesia and the Portuguese colonies. So this work continues through the 1960s and 1970s. The countries of the South insist on describing apartheid as a crime against humanity. And so there are a whole series of General Assembly resolutions that recognize apartheid as a crime against humanity. And these are significant also because they confirm that the notion of crimes against humanity is no longer linked to an aggressive war. In South Africa, at the time, the country is at peace. There is no international armed conflict. There isn't really even a non-international armed conflict, but there's a terrible racist regime. And so this agenda gets put forward through the 60s and 70s. It leads to the adoption of the Apartheid Convention in 1973. It's a convention that was very popular in Africa and Asia and some other parts of the world, but that has never been ratified by the countries of Europe and of North America. And so they become interested in international criminal law's revival only at the end of the 1980s. They basically boycott the attempts to use international criminal law to deal with apartheid. And their concern is with overreach of the notion of apartheid, and in particular, the fact that not only might they or their nationals be charged with being with complicity, with being accomplices in the South African apartheid regime, but they were also nervous about suggestions in the Apartheid Convention that the crime could be prosecuted on the basis of universal jurisdiction. Of course, that never does, in fact, come to pass, and the apartheid regime eventually collapses in 1990. And that's when the process of setting up the International Criminal Court develops all of its momentum through the 1990s, which is a very fertile period, very similar to the post-Second World War period, where in the space of several years, huge steps forward are made, both institutionally, initially with the creation of the temporary tribunals for Yugoslavia and Rwanda, and then with the creation of the permanent International Criminal Court. And as I said at the outset of my remarks, the International Criminal Court has, in some ways, had phenomenal success, more than many would have expected in terms of obtaining the support of so many countries, although it's still far from universality, but also a somewhat disappointing performance in terms of the actual work that it's done, because I think to date, there have been 5 or 6 convictions by the International Criminal Court, an institution that has been in existence and operational now for almost 20 years. And that doesn't compare very well with other international criminal tribunals. When we look at Nuremberg or Tokyo, they of accused. When we look at the Yugoslavia Tribunal, a very specialized niche of a country, of a conflict, and it was able to deal with more than 150 accused in the course of its existence, which is really comparable in length to the existence of the International Criminal Court. And we can say the same about the Rwanda Tribunal. So I think for those who were there, especially those who were there at the creation of the International Criminal Court, and I include myself in that number. I was a delegate to the Rome Conference in 1998 and watched the whole process unfold there, and of course have followed it very closely in the years that followed. And I think that most of the participants at the Rome Conference, if you had asked them to indicate their expectations for the International Criminal Court, they would have thought that by the time it had been in existence for nearly 20 years, that it would have dealt with a very large number of cases. And that is not actually the situation. So one of the things that I think is very intriguing to reflect upon with regard to the International Criminal Court is what's different about it? Why is the International Criminal Court struggling in a way to deal with the various situations, to get offenders before the court, to conduct trials that are of reasonable length and that are effective, to develop an appropriate regime for reparations, which is part of the Rome Statute package, and something that was actually not a feature of any of the earlier international criminal tribunals. And why is this? What's different about it? Well, there are maybe a few main differences about the International Criminal Court compared with the other institutions. One of them, and maybe if I have enough time, I'll return to it, or perhaps some of you will have questions about it, is what we call complementarity. And this is a notion that's built into the Rome Statute that basically says that the court of first resort is the national court, that in principle, accused persons are to be tried by national jurisdictions, and only when that process doesn't work, when it fails, and I don't mean an acquittal, I mean simply that the national system, and the term used in the Rome Statute is unwilling or unable, and to that the judges have added a term of inactive, but for whatever reason, when the national system is not actually doing the job of prosecuting. It's only under when that has been established that the International Criminal Court can be properly activated. And this is something that the law continues to develop on this. This is largely a matter that remains with the prosecutor, because it's for the prosecutor of the court to decide whether or not to proceed. And one of the elements that he must consider is whether the national system is actually doing its job. Last December, the prosecutor of the court, the previous prosecutor, there was a change of prosecutor in June of this year. The previous prosecutor decided to close a kind of examination, a kind of a preliminary, what's called a preliminary examination into the conduct of British troops in Iraq, where we know that the British troops were responsible for various acts of torture, of homicide, of atrocity committed against Iraqi nationals. The court has jurisdiction over that situation, but the prosecutor had to inquire as to whether the UK courts were doing a proper job. And it's a fact that while there have been many investigations in the United Kingdom, there haven't really been any trials. There haven't been any prosecutions. Nobody is in jail. There have been some very handsome out-of-court settlements to victims of these atrocities, but very, very, very little in the way of individual responsibility. But the prosecutor finally threw up her hands and said, you know, I cannot prove that the United Kingdom is unwilling to prosecute these people, and they're certainly able to prosecute them, and they appear to be conducting investigations, but nothing seems to be happening. And the prosecutor, I think in frustration, decided to close the file. So this is one of the difficulties of the notion of complementarity. I recall at the Rome conference, the prosecutor then, the only international prosecutor at the time, Louise Arbour, she was the prosecutor for the international criminal tribunals for Yugoslavia and Rwanda. And she said this complementarity regime will never work because wealthy countries with very developed justice systems will always be able to demonstrate that they are going through the motions of conducting investigations, even if they actually are trying to cover their tracks and avoid doing it. She said it'll be impossible to win a case against them. And she said, so that will mean that the International Criminal Court will be condemned to basically focus its activity on poor countries where it is easier to demonstrate not the lack of willingness so much as the fact that they don't have a sufficiently developed judicial infrastructure to do the cases. And that is, in fact, what's happened, where essentially all of the accused before the International Criminal Court have been from countries in mainly Central Africa, some from North Africa, from Libya. So this is one of the first features of the International Criminal Court, this notion of complementarity, which we don't have with the other institutions. The other institutions were given primacy, which meant that they could override national proceedings. They could simply say, I want to prosecute that person, and there was a legal obligation then to surrender them for trial. And the fact that the national justice system said, actually, we'd be happy to try and prosecute them was of no relevance. The International Tribunal came first. And that's not the case with the International Criminal Court. Arguably, if we had a system of primacy at the International Criminal Court, it might have been able to do much more in the last 2 decades. But of course, this system of complementarity, of deference to the national system, was a political choice. It was a compromise that was made when the statute was being adopted, because states would resist joining a court. They would, let me put it another way, if the International Criminal Court statute provided for the primacy of the International Criminal Court, I don't think we would have 123 states parties. We might have 15 states parties or 20 states parties. So the complementarity rule was very important in getting countries to accept the International Criminal Court. And it provided a kind of reassurance to them that they could avoid the International Criminal Court operating on their territory and with respect to their nationals if they did a decent job of delivering justice for international crimes. The other main difference between the International Criminal Court and the other courts is about the discretion of the prosecutor of the court in the selection of targets for prosecution. If we look at the earliest model, and I referred to this at the outset of my remarks, this is the International Criminal Tribunal, which was contemplated by the Treaty of Versailles of 1919 for the trial of the former German emperor. And now that court was never actually set up, but the Treaty of Versailles specified not only how the court would be set up, but whom it would prosecute. And in the case of the Treaty of Versailles, it's quite precise. It says it's there to prosecute the German emperor. So you could, and if they had gone ahead with this, if the Kaiser had been surrendered, then they would have to have some meetings to determine how the prosecution would take place and who would be the prosecutor, but the prosecutor would have no choice in whom to prosecute. That had been decided by those who drafted the Treaty of Versailles, and that was a profoundly political decision. It was not a judicial determination. It was not the sort of thing that we're used to in national justice systems, where we have prosecutors who are supposed to make determinations about whom to prosecute based on objective criteria, and to do it in an impartial manner, and one that's free of political influence and corruption. The case of the 1919 Treaty of Versailles, there was no such discretion, no such authority with the prosecutor. Much the same was the situation at Nuremberg and at Tokyo. Of course, the prosecutors, because there were multiple prosecutors, in the case of the Nuremberg Tribunal, there were 4 prosecutors, one from each of the participating countries. And they had to agree amongst themselves whom to prosecute. But they could only prosecute Germans, essentially. I think the Nuremberg Tribunal technically could also have prosecuted the Italians and the Hungarians, but it did not. It confined itself to prosecuting Germans and some Austrians, I should say. And that tribunal, within that jurisdictional framework, the prosecutors had a certain amount of freedom to select whom to prosecute. And it's an interesting story how they made those choices. They exercised a form of discretion. They had to agree, the 4 of them unanimously, to do this, which they managed to do. But they were not able to prosecute, for example, the British for the firebombing of Dresden, or the Americans for the firebombing of Tokyo, or for the use of nuclear weapons in Hiroshima and Nagasaki. And the hypocrisy of the situation was, as I'm sure many of you know, highlighted in the famous dissenting opinion of Judge Powell at the International Military Tribunal for the Far East. But my point here again is that the prosecutors, although they had a limited discretion in terms of identifying the individuals, they were confined by their statute, the charter of these international military tribunals, to the leading personalities of the enemy regime, and they could go no further. We have to go forward now another 40 years, 45 years to the establishment of the Yugoslavia Tribunal by the Security Council. And there again, the Security Council set up an institution where it determined a prosecutor who was said to be independent, who was to be independent of political interference from countries, but whose jurisdiction, again, was confined to crimes committed on the territory of the former Yugoslavia. And I think at the time, everybody assumed that it was going to prosecute mainly Serbs and some Croats and a few Bosniaks but that it would go no further, even though there were nationals of other countries who were active on the territory. And indeed, one category of possible suspects was not anticipated at all in 1993 when the Yugoslavia Tribunal was set up. These were the NATO forces who intervened in 1999 with regard to Kosovo and conducted bombing both on the territory of Serbia and within Kosovo itself, and caused extensive damage and arguably committed war crimes. And there were important complaints that were made at the time. There was shock in Washington at the idea that the jurisdiction of the court might in fact cover the American forces because it was a territorial jurisdiction for the former Yugoslavia. They had not anticipated that when the Security Council set up the tribunal. I think it was legally correct that the tribunal could prosecute the Americans for bombing in Kosovo. In fact, the prosecutor took a decision not to do it, and the case was closed, and that never happened. Now, the difference at the International Criminal Court is that the drafters of the statute desperately wanted, most of them, I should say, desperately wanted to get away from the political control of the tribunal, of the International Criminal Court, to some extent because they felt that the idea of political control over the subjects of prosecution was incompatible with judicial independence and impartiality. But I think more importantly, because they didn't know who could be trusted to do the job. And if we look back at the earlier models that they could work with, the Yugoslavia Tribunal was created by the United Nations Security Council. And I don't think I need to go into any detail to explain to you how that body operates and who controls it. If we go back to 1945, of course, the United Nations has not yet been created when the Nuremberg Tribunal is set up, but who actually sets up the tribunal? The United States, the Soviet Union, France, and the United Kingdom, 4 of the 5 future members of the Security Council of the United Nations. And if we go back to 1919, who is it who dictates the trial of the Kaiser in the text of the Versailles Treaty? Again, it's the Americans, the British, and the French, essentially, who do it. So it's these very powerful countries who have dominated global politics and the global economy to a large extent for the last century, who had made those determinations in 1919, in 1945, and then in 1993 with the Yugoslavia Tribunal. But many countries at the Rome Conference, because this is now a more democratic exercise, the creation of the tribunal. Now we have a tribunal that's being created by all member states and even some non-member states who are participating of the United Nations, and they're creating it, and they're going to do it democratically at an international conference, and most of them don't want the Security Council to run things. And so instead, they look for an alternative, and the alternative, which is the one that appears to be the most viable, is to entrust the power of the selection of situations to an independent prosecutor. And that's what we find in the Rome Statute. So this is the great innovation, and it's has been one of the great challenges for the prosecutor. We now are on to the third generation of prosecutors. We've had Luis Moreno Ocampo of Argentina, who was the prosecutor for the first 9 years, Fatou Bensouda of Gambia, who was the prosecutor for the next 9 years, and now Karim Khan of the United Kingdom, who took power as prosecutor in June of this year, of 2021. And these 3 prosecutors have had in the past and continue to wrestle with this problem of selecting the situations. So there are some very elaborate policy papers that have been developed by the prosecutor to explain the factors involved in that selection. But as is often the case, you know, the more you write about the situation, the more obscure it becomes. And finally, the prosecutor has said, has given a series of factors that remind me of a menu in a Chinese restaurant, because they seem to cover everything. And so they make it impossible, actually, to make it possible for somebody who's not the prosecutor to predict what the prosecutor is going to do. And that's really, that should not be the case. We should be able to say the prosecutor will make this choice or that choice, probably, because the prosecutor is governed by these principles, and this is the exercise of the prosecutor's, to govern the exercise of the prosecutor's discretion. But in fact, it isn't possible to do that, in my opinion. And the problem with a court like that, on the one hand, it's the great strength of the International Criminal Court. It's its great strength because it provides, it gives the court freedom and independence from domination by the permanent members of the Security Council, which is a good thing in my book. If they had any control, it would mean that it would be impossible for the court to actually ever exercise jurisdiction on territories that would encroach upon the vested interests of those 5 permanent members of the Security Council. It would mean a court reserved for those people who were outside of that framework. And we can say today that in principle, the prosecutor of the International Criminal Court does in fact have open files dealing with the conduct of the United States in Afghanistan, until recently of the British in Iraq, of the Russians in Ukraine and in Georgia, and of the Israelis, not a permanent member of the Security Council, but clearly protected by one of the permanent members, and Israel in Palestine. And this would have been impossible if the Security Council had, or if the permanent members had the kind of control over the selection of the situations for prosecution that was the case with the earlier models. A great strength, as I say, but this is a case of yin and yang. This is a dialectic. It's also the great weakness of the court, in my opinion. It's the great weakness of the court, because a model of discretion like this, a total discretion that is reserved to a single individual for an institution of the importance of the International Criminal Court, with a budget of 150 million euro per annum, it's unprecedented. There's nothing like it that exists anywhere else. Maybe in the private sector, I suppose Jeff Bezos has total discretion over the exercise of 150 million a year at Amazon. But in terms of an international institution, there's nothing like it. There are 2 problems to this, I think. One of them is that the decisions of the prosecutor, no matter what we say, are imbued with political choices. I think this is inevitable. This is inevitable even with individuals who are principled, in good faith and honest, but they have their own leanings, political leanings, which are not illegitimate, but they shouldn't prevail necessarily at an international criminal court. To give one example, there are currently 2 types of situations presented before the International Criminal Court with regard to Venezuela, what we call Venezuela 1 and Venezuela 2. The prosecutor today is in Venezuela meeting with government officials with respect to these investigations, with these situations in Venezuela. The first one concerns allegations that have come from Canada, some of the states in Latin America, and that also reflect the views of the United States, although the United States can't make a complaint to the court because it's not a member. And this is about a range of allegations of crimes against humanity committed by the current regime. Venezuela on the other hand, has also requested that the prosecutor open an investigation with regard to the sanctions regime that has been imposed by the United States, what we call in international law, unilateral coercive measures. There's a whole body of material on this. There's a special rapporteur of the Human Rights Council. There are resolutions of the United Nations Human Rights Council and of the General Assembly about the impermissibility of unilateral coercive measures, which are, as a general rule, adopted by wealthy countries with very strong and powerful economies against countries that are on their own particular blacklists. So here are two situations that there are people I describe this to, and there are some people who say, I hope that the Venezuelans can get the Americans. And then there are others who say, I hope that the Americans can get the Venezuelans. These are sort of political choices. And of course, the prosecutor will be able to say, I've selected this one for this reason or that one for another reason. But can we really reasonably expect the prosecutor to eliminate these personal political leanings? I should add that we have no idea what the prosecutor's political leanings might be, because the selection process for the prosecutor studiously avoids this, even though the most important function of the prosecutor, in my opinion, is this very delicate selection of the situations for prosecution. When the elections are taking place for the prosecutor, the discussion is confined to technical questions about the expertise and management skills of the prosecutor, as if nobody really wants to know what the prosecutor thinks. The other problem with it is it's more difficult, maybe impossible, to demonstrate, and yet it's a genuine risk whenever you have a single individual with great discretion who exercises such authority. And that is the possibility that that person will be influenced by irregular means, threats, blackmail of some kind or another, perhaps because of something that is not widely known, but that exists in their past, and that states maybe have kept quiet, some states, because they want to use it as a threat, as a veiled threat to get the prosecutor to tip in one direction or another. You know, here I think back to the 1970s, the late 70s and 80s, when Kurt Waldheim, the Austrian, was the Secretary General of the United Nations. And it later came out there were photographs of Waldheim in a Nazi uniform, and the fact that Waldheim had actually been active as a Nazi officer during the Second World War. Actually, this was not a secret, at least to some of the powers. The Americans knew it, others knew it, but they allowed him to be the Secretary General because they could threaten him with exposing him about this. And so I'm concerned about that with the prosecutor as well. I'm not concerned about it because of the individual prosecutor right now, Karim Khan. I know him well enough. We are good friends, and I have no reason to suspect that he's ever done anything irregular in his life. But there are things one cannot know. And my only point here is that the threat of that possibility is something that's real and genuine when you have a single individual who is charged with making those decisions. What's the way forward? I can't make a concrete suggestion, and I can say as well that the difficulty here would be finding an appropriate mechanism to address the problem. That would involve an amendment to the statute. One of the things that the court might consider, if the prosecutor thought that this was a problem, and it's a problem in terms of the legitimacy of the prosecutor's decisions, even if it's not with regard to the legality of the prosecutor's decision, would be to create a council of advisors, of wise individuals who are widely respected, and to have them give some role of participate in some form of governance informally with the prosecutor. And even that would give some greater confidence in the independence and impartiality of the prosecutor in the exercise of these decisions. And as I say, the first prosecutor avoided this danger altogether. The first prosecutor simply focused on Central Africa and stayed as far away as possible from anything that would threaten the most powerful countries. We even found on WikiLeaks that he made assurances to American diplomats that he would not trouble them about the situation in Iraq, not to worry about that. In other words, he managed to send messages that have become public. We have no idea of the other possibility, but we know that he spoke that way to American diplomats when he was the prosecutor. The second prosecutor, Fatou Bensouda, was, I think, somewhat more principled in her dealings, and she did pursue the preliminary examinations of the situation of the British in Iraq, only to give up in frustration, as I explained earlier in my talk. And she did that last December. And to be quite honest, I'm not faulting her for the decision she made. She made a decision that's consistent with the Rome Statute. The Rome Statute protects countries in this manner, just as Louise Arbour had warned, and the prosecutor simply felt she had no other alternative than to close the file. So this is a design defect, one could say, in the statute, but it's not really realistic even to speak about design defects. The Rome Statute, it is what it is. It's what was capable of being negotiated in 1998. It has its flaws, and it's unlikely that the statute is going to be changed in any dramatic way anytime soon. In that respect, it's not unlike the Charter of the United Nations, which, as we know, is an imperfect instrument as well, which has its flaws and shortcomings, and yet the United Nations is a fully operational body, and it deserves a lot of credit for the fact that we've had 75, 76 years without a global conflict, without a world war. So I think that I've probably gone over the time that I was supposed to be speaking. I'm going to stop at this point, this introduction to the International Criminal Court, to a little bit of the history of international justice, and an attempt to identify some of the current challenges that the court faces. I mentioned that I wanted to say a word or two about victims, but I think I'll leave this to the discussion period, and if people feel strongly, you'll have to push me to do this. I'm going to stop here. I thank you very much for your attention.
Yes, thank you so much, Professor, for that, how can I say, like, very much elaborative and illustrative discussion that you gave us. So, Madam, I think now we may be able to open the floor for some questions that the audience may have.
Thank you, Professor. Very informative, and some of the things I am listening for the first time, although that we have been discussing many underpinnings of these improving jurisprudence from Nuremberg to Rome Statute. I'm sure our audience also would have some points to discuss with you very briefly. If they have questions, either they can type or they can ask. Thank you again. Until they ask, may I begin with a clarification, Professor, now for us, that we very loudly speak about the change occurred since Nuremberg and the Far East. However, although the judgments have been so impressive, but the tribunals setting up of which, as well as the decisions given, are said to be rendering victors justice. that we had to start with victor's justice. Do you like to discuss it a bit, Professor, when we are talking about criminal justice, whether that type of a justice would have done real justice to the world?
The term victor's justice is used in different contexts, actually. And I think when it's used with reference to the tribunals of Nuremberg and Tokyo at the end of the Second World War, it is about this issue of selectivity, of the fact that the tribunals dealt with war crimes and other atrocities committed by the Japanese or by the Germans and their allies, and that atrocities committed by other forces were not prosecuted. And I think that's, it's clear that that's one of the great shortcomings of those institutions. And it was designed, the idea in the current period, starting with the Yugoslavia and Rwanda tribunals and now the International Criminal Court, that problem would be satisfactorily addressed or would be resolved. I don't think it's been resolved for the reasons I've just explained about the selection that's made by the prosecutor of the situations for prosecution. We saw this very acutely at the Yugoslavia tribunal, where if you ask the Bosniaks, but also the Croats, who should be prosecuted, they say it's the Serbs. They're responsible. And most of those who were prosecuted were, in fact, Serbs. But there were Croats and there were Bosniaks who were prosecuted for atrocities and convicted. And they would complain that it was a kind of those were token prosecutions so that the tribunal could resist the charge that it was delivering a kind of victor's justice. So they said, we're the human sacrifice in this. We're being prosecuted so that the court, not because our crimes are so terrible, but because the court wants to, the tribunal wants to be able to say that it's not delivering victor's justice. So I think the problem is still with us. And we see it also at the International Criminal Court, where they prosecute situations, as they call them. But these have been, by and large, civil wars, and they've taken sides. And they've prosecuted one side in the civil war and not the other. They've often got into countries, I'm thinking of Uganda, I'm thinking of Mali, I'm thinking of the Democratic Republic of the Congo, where they do prosecutions against rebel groups, but not against the government forces. So the problem is still with us, and it still is a feature of it, and it will be so, I think, as long as we can say that this is that we have this problem of selectivity, because in a domestic justice system, the way we solve that is we have independent prosecutors, and we require, as a question of law, that all serious crimes against the person be addressed by the criminal justice system. But it's not unknown to have claims even in national justice systems. Perhaps you get this in Sri Lanka, where people say that the authorities, the prosecuting authorities, pick on one side and not the other, pick on one group and not the other, deal with the poor and not with the wealthy. These are features of criminal justice everywhere, where you cannot have you cannot be sure that all serious violations are being prosecuted. I saw that there was a question on the chat about the obstacles and challenges in prosecuting the crime of aggression. So I can take a minute or two and answer that question. The Nuremberg Tribunal and the Tokyo Tribunal prosecuted the crime of aggression, where it was called crimes against peace. And in fact, the Nuremberg judgment, the judges famously said that the crime, the international crime against peace, was the supreme international crime. It was viewed as kind of an umbrella within which all of the other crimes were captured, the war crimes and the crimes against humanity. In some ways, that was an answer to the victor's justice charge as well, because it said if the starting point is prosecuting the party that wages the aggressive war, then it's legitimate to prosecute all of the other things they've done in the course of the war. And that maybe if the other side is not responsible, but is in a sense defending itself, which was the case with many countries in the Second World War, then the idea would be, well, then we don't have the same rationale or justification for prosecuting their war crimes and crimes against humanity. Now, at the Rome Statute, there was a lot of hesitation about including the crime of aggression within the Rome Statute. Finally, it was there, and it was listed, but it was in an imperfect, incomplete form, because the statute, as it was adopted in 1998, didn't allow for the court to prosecute it. It needed, the legal framework for this had to be developed. And that only came about with the amendments that were adopted at the Kampala Review Conference in the year 2010. And those amendments entered into force shortly afterwards, but they required also special majorities for the triggering of the exercise of jurisdiction over the crime of aggression. What we have, it would take too much time to explain the details. We have a very, very inadequate framework within the Rome Statute as amended in order to deal with the crime of aggression. We only have now, I think, 42 or 43 states that have ratified those amendments out of 123 states parties that could ratify them. And of those 42 or 43, we've had, I think in the last 4 or 5 years, only 5 have ratified it. So the rate is about 1 a year. And so that would mean that we'll get to universal ratification if that pace continues in the year 2075. I mean, it's unthinkable. So this is the problem. And the other thing is, of course, cannot prosecute the crime of aggression if it's committed on the territory of a state party, even one that's ratified the amendments, but if it's committed by a state that's not a party to the Rome Statute. And so this basically makes it very, very problematic. And so I don't even think challenges is the word. It's more like close to impossibilities, although I would like to see this develop. There's another question. Since the prosecutors must be impartial and independent from external influence, what is your opinion on the usage of AI technology to make a much more impartial preliminary decision making accompanied by a review committee? I'd never really thought about that. I mean, I'm not personally opposed to, no, let me put it another way. I don't think you can make a formula that will enable those decisions to be made. They are the kind of decisions that you know, you cannot have an app, you cannot have a computer program that's going to tell you there are too many factors, but someone, I don't know enough about AI technology, perhaps someone will say, well, they can do it with even more complicated things. It doesn't strike me that it's realistic at this point to really think too much about that possibility.
Any other questions from Professor? Since now Professor has been taking about 1 hour, you know, if you have some further questions, please kindly ask soon. Well, I think we had a wonderful session with Professor Shabers. We received a very illustrative as well as very informative analytical discussion by him. So listening to him with so much experience and study, also research on what has been happening in the previous century to upward, we all thought that the establishment of International Criminal Court as the first ever permanent International Criminal Court in the end of the previous century, with the establishment of the real court in 2002. However, Rome Court, International Criminal Court, cannot be fully immune from some of the allegations against it in terms of credibility issues. And I think including Sri Lanka, many of the South Asian countries are yet to be the state parties to Rome Statute of International Criminal Court. I remember once I wrote an article with a tag mark to ask whether International Criminal Court is a demon or a fairy. Either it is, something totally to be disregarded or to be believed in such a great victory. So I think we are something in between. However, with the years past, with the judgments given, with the failures and successes, I hope that we are speedily progressing toward an era of ending impunity. It has not been done yet. Professor, thank you very much again. Do you have any concluding remarks to be added?
No, thank you. Just to say it's been a pleasure. Thank you for inviting me.
Thank you so much. Mr. Akalanka, can you kindly?
Yes, actually, now I also would like to thank you very much, Professor, for coming on. We haven't even spoken before, but it was an open invitation, and you were kind enough to accept it and then come here and deliver a great speech. Actually, when it comes to international criminal law also, as Madam Santa told, it is not available at the undergraduate level, unfortunately. But many of the master students do get the opportunity to study about international criminal law. And again, there is a reluctancy in the Sri Lankan context, because some of the things are, as you correctly said, they are sometimes political and they are sometimes controversial. So therefore, we have to have certain limits as well. And I hope that we can, further this collaborative effort that we are having. Since this is the third webinar that we are hosting, and we had the opportunity of hosting 3 great scholars, we are hoping to move on with it. In fact, we'll be having another one on 19th, and we hope that one day you will visit us. As you said, maybe would be in your bucket list, right? And hopefully you will come here and we will be able to host you as well. So I would then like to thank Dean of the Faculty of Law, Dr. Sampath Punchihewa, for allowing us this wonderful opportunity, and Madam Vasanta also. I am lucky enough to be her student and still I am her student. So greatly appreciate her presence. And also I would like to mention Ms. Pavitra Rajendran, who was there with us at the beginning, but she had to go. Yes, with that, I think we will conclude, and we will hopefully meet you again quite soon, maybe on 19th of November with another webinar. And till then, I wish you all the very best. Stay safe and good night. Thank you so much.
Thank you, Professor. Thank you so much. Thank you, the audience, and Mr. Akalanka. It's a wonderful session. Fantastic. Thank you so much. Professor, our invitation to you to visit Sri Lanka, well, as Mr. Akalanka said, when the situation would conduce you, that we will extend you a formal invitation. Thank you again.
Thank you so much. Thank you.
Bye-bye.
Thank you.